অসমীয়া সাহিত্যৰ পুৰুধা ব্যক্তি সত্যনাথ বৰাই কৈছিল, উৎগতি কৰাই মনুষ্য জীৱনৰ লক্ষ্য হোৱা উচিত। কিন্তু সেই উৎগতি কিংবা উন্নয়ন কাৰো অনিষ্টদায়ক হোৱা অনুচিত। বৰ্তমানক সুচল কৰিবলৈ যাওঁতে ভৱিষ্যতৰ কথা পাহৰিবলৈ গ'লে সেয়া হ'ব আমাৰ আগন্তুক প্ৰজন্মক আমি কৰা পৰোক্ষ অপকাৰ। We are deeply honored to have Honorable Justice Ujjwal Bhuya, Judge, Supreme Court of India, with us as the chief guest and the speaker for this special lecture.
A discussion on environment or ecology should have preceded a climate change. Anyway, we discussed a lot of things in the morning. I also paid my tribute, homage to the large number of people, unfortunate people, who have suffered because of this sudden flood in Sivsagar and the adjoining districts. Mr. Chaudhary has pointed out that there may be multiple reasons. I have pointed out that there are many reasons. Professors of Guwahati University, IIT, Roorkee, they have given many reasons. But one prime reason is indiscriminate mining which is going on in that part of the state. The other is, of course, the forest deforestation which is taking place. Today it is Sivsagar, tomorrow it can be any other thing. So giving relief, certainly it is required, but it is only a temporary measure. It is a temporary succor. It's some kind of a putting on a balm on the bruised figure of the state. The suddenness of the flood and the intensity of the flood has caught the people unawares, and it has shocked the conscience of the people. It is high time that there is a conscious debate in the state in this regard. The flood, the severity of the flood, it doesn't distinguish that he is a Hindu, he is a Muslim, he is a tribal, he is a non-tribal. It has swept away everybody. So therefore, in this moment of tragedy, people should forget the artificial distinctions which have been introduced into our society. Our society is a cosmopolitan society. Our society is an evolved society. These are elements which have been introduced into our community, into our society. All people should therefore, irrespective of politics, people may do politics, that's a different matter, we are not into that, should get together and ensure that this type of tendencies, dividing people and driving people away from basic issues confronting the society, should be shunned. That was the essence of my concurring judgment, separate by concurring judgment in the recent Atul Mishra case, where I spoke about free speech and fraternity. But anyway, I once again take this opportunity to pay my homage to the unfortunate people who have suffered so much in Sivsagar and the neighboring districts. We are talking of environment or ecology in the Indian context. In the early years of Indian independence, there was no precise environmental policy. The Constitution of India came into force on 26 January 1950. It had a few provisions regarding environment, though the word environment was not expressly mentioned. The objective being to conserve natural resources and to protect the natural environment. In the year 1976, the Indian Parliament drew upon the commitment made by India at the United Nations Conference on Human Environment held at Stockholm, Sweden. The views expressed in the Stockholm Conference forms the core of the basic environmental philosophy in India. That is the core till date. That has found expression in various statutes and government policies. These provisions were inserted in the Constitution of India by the Constitution 42nd Amendment 1976, which included provisions like Article 48 capital A and Article 51A clause G. Students of constitutional law, and I see quite many students here, they know that Article 48A is a directive principle of state policy. It provides for protection and improvement of the environment and safeguarding of forest and wildlife. It advises the state, primarily it is advisory to the state, that while framing laws or executing policy decisions, the state should endeavor to protect and improve the environment and to safeguard the forest and wildlife of the country. Insofar Article 51A is concerned, it's a separate provision of our Constitution under Part 4 capital A, providing for fundamental duties of the citizens. 51AG says it shall be the duty of every citizen of India to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have a compassion for living creatures. In my address to the students, new students of National Law University here, I spoke about the fundamental duty of every citizen of India to inculcate scientific temperament. All these are interconnected, all duties are interconnected. You can't have a compassion for wildlife, or you can't have a feeling for wildlife or the nature without developing a scientific temperament. In fact, the Constitution 42nd Amendment Act 1976 introduced a host of provisions in the Indian Constitution, from amendment of the preamble. Preamble, you will note that in the original Constitution, the word secular and socialism was not there. It was brought in by way of the 42nd Amendment. We will not go into that debate. It has been closed by the Supreme Court in several sessions. Some of these provisions brought in by way of this amendment became highly controversial, both substantively and procedurally, because of the political and the constitutional context in which these provisions were introduced. You will recall that at that point of time, internal emergency was in force, and Mrs. Gandhi was the Prime Minister. Many thought that these provisions were undemocratic and were introduced only with a view to perpetuating power at the cost of democracy. Mr. Shanti Bhushan, one of India's most prominent lawyers, over a period of time, he became one of the foremost critics and legal adversaries of Mrs. Gandhi. He had successfully argued the election petition instituted against the then Prime Minister of India, Mrs. Gandhi, before the Allahabad High Court. And the rest, they say, is history. Just a digression, brief digression, I will come back again. The allegation against the then Prime Minister was that she had indulged in corrupt practices by using her official vehicle and by using her official employees, officers, the government officers in the conduct of the elections, while campaigning for her. I won't go into that, again it will lead to some controversy. In today's context, it is nothing actually. It is nothing if you look at it today's context, but Allahabad High Court declared, found it to be electoral offence and disqualified her. Then it was challenged in the Supreme Court vacation bench, Justice Krishna, this is history. We will not go into that. When the new government came to power in 1977, Mr. Shanti Bhushan was made the law minister of the country. There was clamor all around that all the amendments introduced by way of the Constitution 42nd Amendment Act 1976 should be removed, lock, stock and barrel from the Constitution. There was a hue and cry. It is to the eternal credit of Mr. Shanti Bhushan that notwithstanding his sharp political disagreements with the outgoing Prime Minister, Mrs. Gandhi, and despite overwhelming public demand, he did not touch many of the provisions introduced in the Constitution by way of the 42nd Amendment, like the word socialism, like the word secular in the preamble, Article 48A and Article 51A of the Constitution. That shows the greatness of the man. Not for nothing people are considered great. It is because of such statesmanship exhibited by Shanti Bhushan that the Constitution remains as a silent bulwark telling the state, particularly the courts are part of the state, to protect the environment.